South Africans have just until Friday to comment on the Electricity Regulation Act Amendment Bill. Among others, this act is seeking to allow private producers to sell electricity and also paves the way for Eskom to establish its own transmission business. But what does this all mean for the country's energy crisis, and why is it so important that you and I, ordinary members of the public, have our say on this? Well, let's break it down for you. Bring in project finance lawyer Alessandra Pardini, who's with us via our video link. And it's great to have you on the program. Thanks very much indeed for making time. Let's start with just the elementary explanations, if we can. I mean, so much being said about these amendments having far-reaching effects, in part because they allow for a more competitive electricity generation market. You'll explain what that means, but I'm wondering, does this necessarily mean that there'll be positive spin-offs for end-user costs? In other words, could this mean electricity is cheaper if the market is a whole lot more competitive?
Morning, Ayanda. Morning, viewers. Ayanda, well, this is a very important development in South Africa. And to your viewers, just noting that this is a bill, it's not yet an act. So we are testing the waters here. But it's an absolute shift from our vertically integrated market into a multilateral market. And what that means is we've always bought Eskom electricity. We've only known Eskom as the only generator, transmitter, and distributor. And the Act fundamentally changes that. It basically allows more entrants into the market and to have the ability to buy electricity from multiple generators in the market.
Yeah, and again, you know, the immediate concern, I imagine, for many over-indebted South Africans is, does having multiple suppliers, multiple electricity generators, potentially mean that I pay less for a unit of electricity? Do you see that kind of process unfolding?
Absolutely. I mean, I'm not an economist, but I can tell you that over the past 10 years, obviously we've diversified as South Africa from a coal-based load economy into significant amounts of renewables, which your viewers may not already know, but we have a significant amount of renewables on our grid. And in 2010, when the process started, we were looking at a kilowatt hour charging in the region of R2.70 per kilowatt hour. And we're now in 2022 at 50 cents per kilowatt hour for those renewables. So in the last 10 years, we've seen a significant improvement in the price that Eskom is paying for that renewable energy, and that price is obviously passed through down to the consumer. That's under a procurement program. What the Act now seeks to do in the form of this bill is to actually increase that pool of suppliers, not only a procurement program, but in terms of IPPs directly being able to buy from consumers directly. So consumers can now select who they'd want to buy for in theory through the transmission system operator, which is the new division that Eskom has set up.
Yeah, what the bill is also hoping to do, according to my understanding, is create provision for an operating license to be given to an independent operator who will essentially run the national grid. And, you know, I'm putting it very plainly, but this is essentially someone who's meant to be responsible for ensuring that there's a leveled playing field for these new entrants in a context where, of course, we're trying to move from a monopoly to a multi-party market.
Absolutely, Anna, that's exactly correct. So we used to have Eskom as the only transmission system operator. That's now spun out of Eskom, the company that was done in December. We now have the bill which identifies this entity as a transmission system operator, a separate legal entity. And the bill actually envisages that that could be privately owned within the next 5 years, which is a significant shift away from our world, which is Eskom doing everything. And so that is a very exciting step, that this system operator, or TSO, would be responsible for balancing, trading, and monitoring that whole transmission system for us.
I mean, from a lawyer's perspective, what are the regulatory hurdles, if you like, that need to be jumped in order to get that right? I mean, I can't begin to imagine what drawing up, for instance, the legal framework might look like for any person who's trying to ensure that an Eskom that's been around literally for decades is not necessarily given any kind of particular advantage from new entrants in the form of IPPs.
Sure. So I think the first step is obviously securing a generation license. And that's always been a difficult step for IPPs in the market. NERSA obviously issues those licenses, but the Electricity Regulation Act is obviously the governing legislation around that. And that's been significantly liberalized by this bill itself, and also by a couple of previous exemptions to Schedule 2 of the Electricity Regulation Act, where we saw the opening up of the market. Previously, you had to get a generation license if you were generating in excess of 1 megawatt. That's now sitting at 100 megawatts. So any IPP theoretically can generate electricity up to 100 megawatts without a generation license. They simply need to register with NERSA, which is a phenomenal development that has taken place in the last 12 months. And we've seen the market, just with that amendment alone, liberalize enormously. Heavy industry users are looking at their own electricity requirements and suddenly are able to map out, manage, and essentially forecast how they're going to procure and secure electricity. And often they're doing it through renewables so that they are not reliant entirely on grid connection and not reliant entirely on coal. And obviously that feeds into a whole narrative about sustainability. So this comes at such an opportune time because companies, private sector, is able to liberalize their energy choices, and the Act provides that framework. So the generation license is the first step. Obviously this bill enables power purchase agreements or direct supply agreements to be concluded between generators and end users. And this bill is saying that those agreements will not be regulated by the Electricity Regulation Act. Those private agreements can now happen, which is a phenomenal step forward. And better than that, they don't have to be co-located. So you don't have to be generating on the same site that you are off-taking or using. You can use Eskom's grid to do that. So you can be generating in Cape Town and you can be using that electricity in PE. And that's done through the grid through a concept called wheeling. And that's all enabled through existing legislation and Eskom's transmission unit, which manages wheeling. And this bill only emphasizes that that is the vision going forward. So it's a phenomenal change.
Yeah, far-reaching implications here. I guess those people who have been branding this bill as an anti-load shedding piece of legislation, perhaps they're not overreaching. I mean, would you agree with that sentiment?
Yes, and the most significant change in that space is you now have a multi-market system where you can procure energy on a day-ahead or a week-ahead market. So the transmission system operator would be managing all this forecasting, and you as a consumer theoretically could be able to purchase in an open market. And if there is an open market, of course, we're in the absolute realm of supply and demand. And that supply and demand is the ultimate way to solve load shedding, because you and I now don't currently have a choice to buy from anywhere other than Eskom,
right,
or if you've got your own generation on site or your generator. So the very creation of the day-ahead market is absolutely a panacea to load shedding.
Yeah. Of course, there are benefits for end users, ordinary consumers, which is the bulk of the people who are going to be affected by this. But there's also, I guess, a conversation to be had around how easy it is as an IPP to enter into this space and become part of this multi-market generation system. Are you worried about any potential barriers to entry for people who are hoping to make the most of these amendments?
Sure. I think there are a few barriers to entry, and I think there are three kind of areas that we focus on. There's the rooftop space, which is small projects, which obviously CapEx is not a big issue, and there is various funding available for those sorts of projects. They're in the more affordable space, and you and I as the end user can procure funding or get IPPs to assist us with that in the small space. Then there's kind of the 10 megawatt space, and then there's the utility scale space. In the utility scale, anything above 50 megawatts to 100 megawatts, there are big project finance, commercial banks, development finance institutions that are keen to finance that infrastructure. So there's a lot of funding available. It's that space in the middle that's a little bit tricky because getting lawyers, getting technical advisors, getting financial advisors is an expensive process. And also banks aren't keen to always fund that small space because the margins are the biggest. So I think we need to be carefully watching that space and understand what mechanisms can we unlock to assist those kind of users and to assist those IPPs getting into the space. The tech is readily available. I think South Africa needs to look at local content seriously and understand what can we do in the space instead of outsourcing all those requirements to China and the West. And I think there is a place for our very developed engineering industry and manufacturing industry to get involved. And I also think that, this is a job creation opportunity. So we have seen that in the IPP procurement program. Governments put very rigorous job creation, economic development objectives, and the IPPs have met that. So that is possible, and I think we should just continue that into this next phase, into the various spheres, both small, medium, and large scale. Yeah,
sounds promising. But very quickly, Alessandra, this is just, Friday, that is. It's just the end of the public participation process, public comments. There's still quite a long way to go from this moving from a bill into an act and, things finally materializing.
Absolutely. Commentators are saying this could take up to 2 years, which is slightly frustrating, but the existing legislation does provide a useful framework to get that implemented in the interim. And I think it is important for those that have good views on the current amendments to participate. Essentially, this is, why we live in a democratic country and part of our democratic process, for you, the public, to enable yourselves to comment on any of those changes. And I think, there are some useful amendments that would be required. There's a little bit of tidying up, and I think the IPPs should look into this. And, there are many advisors out there can happily assist you in providing comments. But I think it's a great step forward.